Today, we're going to be discussing about what appears to be a leaked memo or a leaked document that is suggesting that the Biden administration is going to attempt to outlaw private party transactions for firearms if the resulting transaction results in a profit. AmmoLand is reporting that they have received intelligence that the Biden administration is considering the idea by the end of the year of coming up with an ATF rule that would prohibit the transfer or the selling of firearms by private individuals for a profit, assuming that the individuals do not have an FFL. Now, many of you guys have recently seen my video that we talk about Chevron deference and how that is probably going to be overturned. And this video is going to get a little wonky. I'm going to warn you about that right off the bat. But it's I think it's very, very critically important. So in the previous videos where we've talked about Chevron deference, we mentioned that the Supreme Court is going to most likely be overturning the concept of Chevron deference, which essentially says that if Congress has not regulated a specific form of activity, then the administrative agency, in this particular case, the ATF, is free to go ahead and make their own laws. And it's been this way for a number of decades. It looks like the Supreme Court is going to overturn that, which is unbelievably good. All right. The rule-making authority, the power to construct laws should not be vested in an unelected executive agency populated by bureaucrats. They should be vested exclusively within the legislature because each member of the legislature is subject to electoral recall. If they do something that enough people disagree with, they can simply be voted out of office. You don't have that ability when you're dealing with an executive agency. So over the years, executive agencies like the ATF have developed a number of rules that effectively have the force of law. Now, the Biden administration has made the decision, at least it appears, that they've made the decision that they're going to use the ATF, notwithstanding Chevron, they're going to use the ATF to regulate private party transfers. The ATF on their website has a list of things that you are required to have an FFL for. Primarily, you need to have an FFL if you are engaged in the business of selling or transferring firearms. And then it gets into somewhat of a granular analysis, right? They give you a bunch of hypotheticals. So for instance, one of the hypotheticals that they postulate is that someone has accumulated a number of firearms throughout their life, and now they're looking to liquidate that collection for retirement or for whatever reason. That action would not require an FFL, because by definition, they're not in the business of selling firearms. Now, on the other hand, let's say someone buys a gun and then chooses to sell the gun and makes a profit at that, with that sale. This may, even with one firearm, this may run afoul of the 1968 Gun Control Act that creates the FFL to begin with. It becomes a fact-dependent analysis, right? We had a case in our law firm, we had a case of an individual that had accumulated a number of weapons and was using FFLs to liquidate that collection. Unfortunately, then the reason he fell within the scope of the ATF, or at least their mindset here, was that some of the guns that he was collecting and then subsequently selling, he only owned for a brief period of time and was in fact selling them for a substantial profit. Now that case is, we ultimately got that case resolved, but it still forced him to litigate it. Hey guys, I'm pausing this video for just a moment. USCCA, they are doing a special giveaway right now. It's very cool, and you can see what it is in the descriptions below of this video. You'll definitely want to click on it. You're going to want to participate very soon. It ends quickly. All right, let's get back to the video. So, there's this sort of rubric that exists that says you need to have a license in order to engage in this type of business. Now, where it gets a little nuanced and where a lot of people get really, they lack the understanding on this is that, let's say you have an individual that has a collection of firearms and, some of them recently acquired, but he's now made the decision, or she's now made the decision that she wants to sell them. And because of scarcity in the marketplace, they're going to sell for more money than they had originally purchased them for. And not wanting to sell them out of the back of a pickup truck or something like that, they go to an FFL and ask the FFL to assist them in selling their firearms. Well, the ATF could still see this as being engaged in the business of selling firearms. This is exactly, by the way, what happened with our case that I just mentioned. It wasn't like he was selling these guns without using an FFL as an independent third-party system. He was, and yet the ATF still tried to go after him. This new proposed rule that the Biden administration is suggesting would eliminate effectively all private party sales completely, from what I could basically understand on this one. Now, it's really unclear from the article that I read in Ammo Land as to how exactly they would intend to do this. It's unclear as to whether or not they're saying that in states that do not require FFLs for private party transactions, you simply would now need to use an FFL, or whether or not they're going to say, hey, if you net a profit on the sale of the gun, you've run afoul of the 1968 Gun Control Act. Again, it's vague. It doesn't say anything about that. The argument that they're already floating is that because of the Safer Communities Act that Congress recently voted on and passed and President Biden signed into law, they're saying that this specific regulatory scheme actually does fall within ATF. They're saying, look, even if Chevron's overturned, okay, Congress can legitimately sit there and say, we're not going to get into the granular analysis at the legislative level as to what constitutes a private party sale or something along those lines. We are going to transfer this type of analysis to the executive agency. We've purposefully given them this power. It's not like we simply were silent on it and the executive agency decided to do it on their own. We are specifically telling them, come up with a program and then implement that program. At least that's what their argument appears to be. I don't know whether or not that will be sufficient. Okay, if Chevron's overturned, simply having Congress say, well, you guys do this may not be enough. We haven't actually gotten a decision yet on this, so we don't know how nuanced the opinion's going to be or how it's actually structured. In that respect, we're going to have to wait and see. Regardless, okay, whether or not there's a carve out or anything like that, the very concept is unbelievably noxious, okay? One of the fundamental tenets of private property is the ability to alienate yourself from that property. And if they are able to make a legitimate argument that you cannot sell something, I mean, let's say for the sake of argument that you bought a firearm in 1980 and because of market forces, that firearm has now gained 20% or 40% in value. All right, well, unless you go and get an FFL, there would be, under this theory, I guess, no actual way of being able to transfer that gun. More importantly, what happens when you die? What happens when this property now vests in your heirs? All right, well, that gets valued, right? That transference creates a value proposition, and now you've got somebody receiving property that is at a greater value than it was originally transferred. And clearly the decedent didn't have an FFL. The Pandora's box here is just absolutely staggering. But more importantly, this goes back to the alienability concept. If you have property, you have to be able to liquidate that property. If you don't have the ability to liquidate that property, you actually don't own it. What you really have is a license to possess it. And I think that may be the underlying philosophy that the Biden administration is trying to slowly promulgate. You, as an individual, have the right to keep and bear arms, but you don't necessarily have the right to own arms. At least that's their concept. Perhaps you have nothing more than a right to have a license to be in possession of the arms. Maybe the government actually owns all of the arms, and you are simply, as an individual, allowed to possess them for a specific period of time. And of course, that license is simply going to be whatever the underlying value of the firearm was at the time of acquisition. But you don't have a legitimate method of being able to dispose it and recoup your initial investment. This is really problematic. It'll be fascinating to see how this ultimately plays out. Again, they're saying that they want to do this apparently by the end of the year, which will be prior to the ruling that we get in from the Supreme Court, potentially overturning Chevron deference. That won't be until early summer of next year. So, we'll wait and see. AMOLAND did a great job in reporting this information, and we'll see how it ultimately plays out. As always, if you want to contact me, please do so by email at steven@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.